Good evening, everybody. Today, my topic for presentation is General Principles of Criminal Liability. Going to the first slide, that is table of contents. Then, concept of crime. First point is the primary function of every state is maintenance of peace and order in society. It means and includes protection of life, liberty, and property of persons from enemies and wrongdoers. Explanation of this point is protection of life, liberty, and property of every citizen from wrongdoers or criminals, and maintaining peace and justice in the society is the chief important duty and function of every state. Going to the second point, that the instrument by which the state discharges its primary functions of maintenance of law and order is called the penal law. In order to keep this peace in society, state will use certain tools. These tools for maintaining law and order is called penal law. Crime means any act or omission on part of an individual which threat the peace and order in the society or security. The explanation for this point is crime means any activity or omission. Omission means failure to fulfill legal obligations doing by individuals. The result of such act is a threat in the peace, security, and order in the society. And the next point is crime is an unlawful act that forbidden and punished by the state. Under law of crime, crime is an unlawful act that is forbidden or banned and punished by the state. And in criminal procedure code, the last point is concept of crime under this criminal procedure code defined as the term of offense. Moving to the next slide. Definitions of crime. Section 2 clause N of Criminal Procedure Code defines offense. And the Indian Penal Code defined crime as an action committed or omitted which constitutes an offense and punishable by law. Here, Section 2 clause N of the Criminal Procedure Code defines offense means any act or omission made punishable by any law for a time being in force and includes any act in respect of which a complaint may be made under Section 20 of the Cattle Trespass Act 1871. Moving to the next point, definition of crime according to renowned jurists. So many jurists, all of you know that Austin, then Blackstone, according and Stephen and Kenny, Keaton, Halsbury laws of England defined in various aspects of definition of crime. First is Austin. Austin says that a wrong which is pursued at the discretion of the injured party and his representatives in a civil injury, a wrong which is pursued by the sovereign or his subordinates is a crime. Austin categorized crime as civil injury and criminal injury. In his definition, he described that in civil case, it is affecting to injured party and his representatives, and in criminal case, it is affecting to the state also. According to Blackstone, an act committed or omitted in violation of a public law, either forbidden or commanding. In his book, Commentaries on the Law of England, he defines this definition. That according to Blackstone, crime is a violation of public law. Then Stephen, Kenny, Keaton, other jurists defined crime. And one of the important definition is made by Halsbury's Laws of England. A crime is an unlawful act default which is an offense against the public and renders the person guilty of the act liable to legal punishment. Halsbury Laws of England says that offense is an unlawful act against the public. Moving to the next slide, that is history of criminal jurisprudence. The word crime is derived from the Latin root carno, meaning I decide, give judgment. Originally, the Latin word crimen means charge or cry of distress or accusation, and the Sumerian people are produced the earliest written of criminal laws. Coming to the Indian scenario, Vedic age is the primitive stage of codification of criminal law in India. The history of criminal jurisprudence in India can be found from Vedas, Shrutis, Smritis, and Manusmriti. Manu is known as the first lawgiver and Manusmriti is the first law book. Punishment, according to Manusmriti, punishment varies with the status of Varna system. In the Varna system, Brahmin got the less punishment, and the low status people got high gravity of punishment. Then Islamic age, Quran is the main source of punishment and criminal law in Islamic period, and the administration of justice was vested in the hands of qazis. The next is an important point that British era, the effect of British India in the criminal jurisprudence. That is, when Britishers came to power, the Mufassal and Presidency courts gradually turned English law for guidance. Here, Presidency courts means these courts decide only civil cases, and Mufassal courts deciding district level of criminal courts. And then next point is Warren Hastings introduced his judicial plan of 1772. He abolished the practice of allowing male relatives of victims to pardon their killers among Europeans. Then history of Indian Penal Code. It is very important. That is Charter Act or Government of India Act 1832 or Saint Helena Act 1833. It is otherwise known as in these two names. And Charter Act is very important that under this act, Lord William Bentinck became the first Governor General of India. The objective of Law Commission was to inquire into the jurisdiction, powers and rules of courts of justice, police establishments, existing forms of judicial procedure, nature and operation of all kinds of law. Other members of this commission were English barrister Cameron, Mark Lord, William Anderson and Millett. The significance of Charter Act, there is the end of English East India companies as a crown field of administration, and elevation of Governor General of Bengal as Governor General of India. These two are important significance of Charter Act. Law Commission under Lord Macaulay codified the laws and separated legislative functions. Under the chairmanship of Lord Macaulay, drafted Indian Penal Code and submitted to the Legislative Council in 1856. Then the next point is features of Indian Penal Code 1862. Penal Code of a country consists of all the laws that are related to crime and punishment. The Indian Penal Code, IPC, is the official criminal code in India. It is a comprehensive code intended to cover all substantive aspects of criminal law. It follows the lex loci principle. Lex loci means the laws followed in the land that where the occurrence happens, that principle will follow. That is the meaning of lex loci principle. IPC contains 552 sections divided into total 26 chapters. IPC's amendment totally 77 times IPC amended, and first amendment was made in the Repealing Act 1870. And other latest amendments are Criminal Law Amendment Act 2013, Criminal Law Amendment Act 2018, the Jammu and Kashmir Reorganization Act 2019. This is very important, that is Jammu and Kashmir Reorganization Act, because before that IPC is excluded from Jammu and Kashmir. Now IPC can apply through Section 95 territorial extent of laws, and IPC can apply the Union Territory of Jammu and the State of Kashmir and the Union Territory of Ladakh. IPC extended Goa, Daman, Diu. It extended to Dadra, Nagar, Haveli, Pondicherry and Lakshadweep in various years, 1962, 63 and 1965. Then is territorial and extraterritorial application of IPC. Section 2 deal with territorial, and section 3 and 4 deal with extraterritorial. There is an important case that Enrica Lexi case, that all of you know that the fact of this case. In this case, the Supreme Court held that the crime happens in the beyond the 12 nautical miles from the Arabian Sea. That two Italian marine engineers killed the two Indians from the Arabian Sea. That is the fact of this case. And then the next point is extraterritorial jurisdiction means in this regard includes section 3 and section 4 of the code. According to section 3 and 4, code is applicable to outside Indian territory to Indian citizens and any person on any ship or aircraft registered in India. Then the main part of this presentation is general principles of criminal liability. The main points are actus reus, mens rea, vicarious liability, strict liability, joint liability, group liability or common intention, and common object. First point is essential elements of crime or the main principles, that is based on the principle of penal liability is contained in the maxim actus non facitrium nisi mens rea. It means an act does not amount to crime unless it is done with a guilty mind. This maxim is categorized into two words, that is actus reus and mens rea. Actus reus means any act prohibited by law and mens rea means guilty mind. These two concepts is not been defined in any part of IPC, but the term mens rea we can see in the sections of intentionally, fraudulently, dishonestly, voluntarily, etc., and in motive, recklessness, knowledge, negligence. In this part we can see the essence of, impliedly there is the essence of mens rea. In the following cases, mens rea is not necessary to a person. Where a statute imposes strict liability, example Narcotic and Psychotropic Substance Act 1985, when it is difficult to prove mens rea, and in case of public nuisance, and in case of mistake of law. Next point is actus reus. Actus reus means any act prohibited by law. It is the Latin term used to describe a criminal activity. It is also known as illegal act or omission. Next point is there are two types of actus reus, commission and second is omission. The commission is a criminal activity that harms a person or property. For an example of physical assault, murder, hurt, etc. And the omission is another form of actus reus, an act of criminal negligence. Negligence is an best example for the omission. Next point is mens rea. It is an evil intention of mind is essential element to commit a crime. Otherwise, a person cannot be held liable and punished. For an example, A points revolver on B and say to open the lock of the house of C. Here, B act is not voluntary, but it was against his will. So, in this illustration, B is not liable because there is lack of mens rea. There is lack of intention, and intention and motive is different element, because in this following illustration we can see that if A steals bread from a shop due to hunger, here motive is good, but still he is liable for stealing, because stealing is, there is an essence of mens rea or mental intention. So his motive is good but intention is bad. There is cases R versus Prince, Om Prakash versus Punjab, AR 1961. First case is Prince took away a girl below 16 years of age from possession of father against the will of her father. Prince argued the girl told him that she was 18 years and the intention was bona fide as she was looking like 18 years old girl. The court held that there is given benefit of doctrine of mens rea because this case is mistake of law. So it is an exception to looking the mens rea essence, because it is under the strict liability of mistake of law. So he was held that he was guilty. Om Prakash versus Punjab, another case. And next case is important case, that State of Maharashtra versus M.H. George, AR 1965. M.H. George was a passenger on a Swiss plane traveling from Zurich to Manila. On the way, the plane landed in Bombay on 28/11/1962. It was discovered that M.H. George was carrying 34 kilograms of gold bars in his custody. As an offense, an action was started against Mr. George under relevant sections of FERA, and he was punished in the appeal filed by Mr. George. He pleaded absence of mens rea on the ground that the relevant law was unknown to him, and the court held that the circumstance of this particular case, the rule of mens rea is not applicable. And next case is Natulal versus State of MP. Moving to next slide, that is vicarious liability. This principle, vicarious liability, is based on two maxims. First maxim is respondent superior, let the superior be liable, and second maxim is Q facit per alium facit per se. Meaning of first maxim is let the superior be liable. Meaning of second maxim, master will be liable for the work of his servant. That is the main point of this vicarious liability. The criminal liability of corporates also included in this vicarious liability principle. Next point is strict liability. A person be held liable criminally even if that man has not intended a particular act which has been prohibited by law. And example, offense against state, waging war against the government of India, section 121, and sedition, section 124A. But one day before Supreme Court of India set aside this sedition, put on hold. So in future, I think it is excluded from strict liability. Then other example, assaulting or obstructing public servant and counterfeiting, section 232, and kidnapping, section 359. So next point is joint liability or constructive liability or group liability with common intention. Section 34 to 38 deals with joint liability or constructive liability. That is section 37. First of all, section 34 reads as act done by several persons in furtherance of common intention, and 35 similar intention. Another important section is section 37, who are intentionally cooperate in the commission of that offense by doing any one of those acts, either singly or jointly with any other person commit that offense. അതൊരു ഇല്ലുസ്ട്രേഷനിലൂടെ പറഞ്ഞാൽ കുറച്ചുകൂടി ക്ലിയർ ആവും. The A and B agreed to murder Z by several at different times, giving him small doses of poison. As a result of poison, Z died. A and B are guilty of the offense through their acts are separate. ഇത് സെപ്പറേറ്റ് ടൈമിൽ സെപ്പറേറ്റ് പ്ലേസിൽ എയും ബിയും സെറ്റിനെ മർഡർ ചെയ്യാൻ വേണ്ടിയിട്ട് സ്മോൾ ക്വാണ്ടിറ്റി ഓഫ് പോയിസൺ കൊടുത്തുകൊണ്ടേയിരുന്നു. ആസ് എ റിസൾട്ട് സെഡ് ഡൈഡ്. So here A and B also, both of them are guilty for the offense of acts are separate. Then next section is section 38. Persons concerned in criminal act may be guilty of different offenses. Illustration is A attacks Z under the circumstance of grave provocation in his killing of Z. A attack ചെയ്തു സെഡിന ബിക്കോസ് ഒരു പ്രൊവോക്കേഷൻ ഉണ്ടായിരുന്നു സെഡിന്റെ ഭാഗത്തുനിന്ന്. അപ്പോൾ ഇത് കൾപ്പബിൾ ഹോമിസൈഡായി മാറും. ബട്ട് ബി അതേ ടൈമിൽ തന്നെ ഒരു ഗ്രേവ് പ്രൊവോക്കേഷനും ഇല്ലാതെ ബി സെഡിനെ മർഡർ ചെയ്തു, എ അറ്റാക്കും ചെയ്തു. അപ്പോൾ ഇവിടെ ഈ ഒരു ഇതിൽ പ്രൊവോക്കേഷനിൽ ബി അറ്റാക്ക് ചെയ്തതുകൊണ്ട് എ അറ്റാക്ക് ചെയ്തുകൊണ്ട് എ ഇസ് ഗിൽറ്റി ഓഫ് ഓൺലി കൾപ്പബിൾ ഹോമിസൈഡ് ആൻഡ് ബി ഇസ് ഗിൽറ്റി ഫോർ മർഡർ. Next point is essential elements. There was a common intention in sense of pre-arranged plan between them. They had participated in some manner in the act constituting the offense. Next case is State of Punjab versus Fajwa Singh. The common intention case. One of the important cases regarding common intentions under section 34 is Barendra Kumar Ghosh versus Emperor. Postmaster murder case. It is very familiar to us, AR 9025. That while the postmaster was counting money in his office, three men, including the accused, went into the office and demanded money. On refusal, one of them shot him and he died. One of the contention raised by the accused was that he was not liable as per section 34 and he had not fired and deceased. But the court held that commission of the crime was furtherance of the common intention of all three men. He was held to be liable murder. Next case, Heduba versus State. Next point is common object under section 149. It deals with every member of unlawful assembly are guilty of the offense committed in prosecution of common object. This common section 149 deals with common objectum, 34 common intentionum. Essential ingredients: there must be 5 or more persons. Commission of an offense by any member of such assembly. Such offense must have been committed in prosecution of a common object of the assembly. അപ്പോൾ ഈ ഒരു 3 എസെൻഷ്യൽ ഇൻഗ്രീഡിയൻസ് ആണ് ഇതിനുള്ളത്. ഇത് കുറച്ചും കൂടി നമുക്ക് ഈസി ആയിട്ട് മനസ്സിലാക്കാൻ വേണ്ടിയിട്ട് കോമൺ ഇന്റൻഷൻ കോമൺ ഒബ്ജക്റ്റും തമ്മിലുള്ള ഡിഫറൻസ് എന്താണെന്ന് വെച്ചാൽ, കോമൺ ഇന്റൻഷന്റെ കേസാണ് ഇന്ദിരാഗാന്ധി മർഡർ കേസ്. അതായത് സത്വാൻ സിംഗ് ബിയാൻ സിംഗ് എന്ന് പറഞ്ഞിട്ടുള്ള രണ്ട് ബോഡി ഗാർഡ്സ് ആണ് ഇന്ദിരാഗാന്ധിയെ വധിച്ചത്. അപ്പോൾ അവർ ചെയ്ത ആ ഒരു പ്രീ പ്ലാൻഡ് മർഡർ ആയിരുന്നു. അത് കോമൺ ഇന്റൻഷൻ 34 ആണ് അതിന്റെ മെയിൻ ഇൻഗ്രീഡിയൻറ്റ്. പക്ഷെ കോമൺ ഒബ്ജക്റ്റിന്റെ കേസാണ് ഈ രാജീവ് ഗാന്ധി അസാസിനേഷൻ കേസ് ഉണ്ട്. അപ്പൊ അതിൽ പേരരിവാളൻ, നളിനി, തനു, അങ്ങനെ 5-6 പേരുണ്ട് ഇതിന്റെ മെയിൻ അക്യൂസ്ഡ് പേഴ്സൺസ്. അവർ തമ്മിൽ ഈ പേരരിവാളിനാണ് മാസ്റ്റർ ബ്രെയിൻ ഇതിന്റെ. പക്ഷെ ഈ തനു എന്ന് പറയുന്ന മനുഷ്യ ബോംബായിട്ടുള്ള ആള് ഈ പേരരിവാളിനെ കണ്ടിട്ട് പോലും ഇല്ല. പക്ഷെ അവര് there is a sense of common object. അവർ കോമൺ ഒബ്ജക്റ്റ് ആണ് രാജീവ് ഗാന്ധിനെ വധിക്കുക എന്നുള്ളത്. ബിക്കോസ് ഹി വാസ് അഗെയിൻസ്റ്റ് ദി ക്രിമിനൽ ആക്ട്സ് ഓഫ് their group. അപ്പോൾ അവർ തമ്മിൽ ചില ആൾക്കാർ ചെന്നൈയിലാണുള്ളത്, ചില ആൾക്കാർ ശ്രീലങ്കയിലാണുള്ളത്. പക്ഷെ ആ ഒക്കുറൻസിൽ അവർ ഒന്നിക്കുകയാണ്. പ്രീ പ്ലാനിങ് ഒരുമിച്ച് ചെയ്തിട്ടില്ല. അപ്പോൾ അതൊരു എക്സാമ്പിൾ ആണ് കോമൺ ഒബ്ജക്റ്റിൻ്റെത്. ഇന്ദിരാഗാന്ധി അസോസിനേഷൻ കേസ് എക്സാമ്പിൾ ഫോർ കോമൺ ഇന്റൻഷൻ. അപ്പോൾ ഇതിൽ ഡിഫറൻസ് ചെയ്തിട്ടുണ്ട്. ഡിഫറൻസ് ബിറ്റ്വീൻ കോമൺ ഇന്റൻഷൻ ആൻഡ് കോമൺ ഒബ്ജക്റ്റ്. Common intention, the act must be the result of pre-arrangement. Common object, no such requirement is necessary. Is applicable when 2 or more persons committed a criminal act. Common object, 5 or more reasons required. ഇത് common intentionally specific offense വേണമെന്നില്ല. Common objectil specific offense ആയിരിക്കണം. Specific offense means terrorism, crime against children, women, അതൊക്കെ specific offenseൽ വരുന്നതാണ്. Moving to the conclusion part, I'm concluding this session. As a conclusion part, British rulers played a dominant role for the foundation of our law of crimes in India, and actus reus mens rea both play a significant role in an offense. And the actus reus mens rea, vicarious liability, strict liability, joint liability, common intention, common object are the main general principle of this criminal liability. Then bibliography. I have made some multiple choice questions in NET exam 2018. The term mens rea is defined as the first question. The answer a guilty mind. Then point out the correct statements. 4 statements തന്നിട്ട് അതിൽ crime is necessary an anti-social act ആണ് crime എന്നുള്ള ആൻസർ വരും. പിന്നെ നെറ്റ് 2013 ക്വസ്റ്റ്യൻ ആണ്, who was responsible for the judicial plan of 1772? That is Warren Hastings answer. Then the maxim 2014 question, the maxim reum lincum non facienisi mens rea is propounded by options Coke, Lord Kenyon, Augustine, Lord Arbidgen. Option C Augustine ആണ് answer. Then UGC net 2013 the Indian Penal Code no more denote a positive evil intent for fixing liability. However, there are certain type of act which signifies one to care as culpable resulting out of breach of duty, what it is known as. അതിന്റെ ആൻസർ വരിക നെഗ്ലിജൻലി ആണ്, അതായത് മെൻസ് rea and essence ഉള്ള നെഗ്ലിജൻലി. So thank you. I'm concluding. Thank you all.
Compensation for certain loss is concerned. See here, what is the perspective from which we look at corrective justice? Of course, that is a concept of corrective justice, but not from this perspective.